I'm gonna keep it 100 real with you. A lot of attorneys don't want to go to trial because they've never done a trial. He could likely lose everything. I'm not one of them, but a lot of attorneys will try and talk tough just to settle. I would go to trial. All right, this dad said he's in the later stages of custody battle. So it sounds like it's about to go to trial. It was filed in 2022 in Cook County, and they have a trial date in a few weeks. He brought her to court and asked for this. The child is 1 year old and will be 2 in a couple of months. They're both willing to parent according to the court. They own homes, have good jobs, but they're not able to co-parent. The GAL describes their relationship, meaning the mom and dad in this case, as very high conflict. This guy admits it is. The mother won't agree on anything that he tries to bring up. The only thing he's ever asked for is joint decision-making and 50-50 parenting time. So in the last proposal, they reduced his parenting time to about 6 overnights every 2 weeks. And that was the first time they were willing to accept less than 50-50. His attorney recommended that he settle because the GAL is hinting at recommending full decision-making to the mother and possibly reducing his overnights. He currently has 4 overnights every 2 weeks through their temporary order. The settlement negotiations, they have agreed on all issues, including joint decision-making, except for parenting time, and mother says that she wants the same time if they settle before trial, meaning the same temporary time to be in place. And the mother says if they go to trial, she's basically going to rescind the agreement and ask for full custody of everything, which is all the decision-making regarding medical, education, extracurricular, and religion. And she's going to ask for full custody, meaning he has 0 overnights. Let me pause there. I don't see how that would ever happen. His attorney says if they go to trial, he could likely lose everything that they negotiated for. His attorney also says it's likely the judge will adopt the recommendation of the GAL and likely give sole decision-making to the mother and move him to 4 overnights or less. His heart says go to trial, but if he doesn't get joint decision-making, then he will never get that back. So he really wants to know, should he settle for the little bit more that she's giving him or go to trial? I'm gonna say this. A lot of attorneys don't want to go to trial because they've never done a trial. I'm gonna keep it 100 real with you. I'm not one of them, but a lot of attorneys will try and talk tough just to settle. In addition to, attorneys don't like to go against the GAL. Don't know why. I actually love when there's a GAL in the case because the GAL is a witness. That means that GAL can get on the stand and I can cross-examine you and I can directly examine you. Both parties are presumed to have joint custody unless you're able to prove serious endangerment. It sounds like this young man is already at a time where he's getting overnights. It's unsupervised, and all he wants to do is essentially be the equal parent. I would go to trial.